Am I audible?
Yes, sir. Yes, sir. You're absolutely audible. Very good afternoon, sir. Very good afternoon
Welcome everyone.
to all the participants also. Sir, it's an opportunity that today again we have Professor Anand Pawar with us, and it is, it is also a pleasure because Sir has been associated with our university at various levels, and he has always supported all our academic endeavors. As far as the academic accolades of Professor Pawar is concerned, he's taught at several universities, okay, among which some of the law schools across the country, including HNLU, the Ayatollah National Law University, and currently where Sir is teaching, that is RGNUL, some of the institutions. During his tenure at RGNUL, he has also been officiating Vice Chancellor. He has written and co-edited and authored more than 15 books, and there are numerous articles which have been published in journals of international repute to his credit. And today we have this opportunity of hearing from Professor Pawar, and Professor Pawar has agreed to discuss the tenets of Mimamsa philosophy, isn't it, sir?
Yes.
Yeah, so Mimamsa philosophy and how its applicability is there in the current legal framework of the country. So once again, sir, on behalf of the HPNLU family and also the participants, I welcome you and I hand over the virtual dais to you, sir. Thank you so much, sir.
Thank you so very much for your kind words. And I'm more thankful to you for providing me this opportunity to discuss one of the very specific area which even I am exploring for the first time since your MDP is in with reference to the Hindu philosophy and ancient text. So I thought that one of the area which is relevant for all of us, be it as a researcher, be it as an academician, the Mimamsa principles. Specifically, it applies on different dimensions. But the basic purpose of taking this topic is that perhaps we all know that our ancient text was very rich, and probably there were multiple kind of propaganda of Western world, whereby sometimes they have not given due credit to the Indian text or very rich text which is available with us, and some of the text which has been copied or the ideas were obtained from those all ancient texts, and then it was branded with the Western world, avoiding it. So somewhere the rich text or the kind of system which applies in almost all dimensions of the life, be it as economic, political, legal, educational, in all dimensions, there were some of specific rules which were prevalent. And all those rules which are still up to an extent relevant and pertinent in the present context. So my basic purpose for today's discussion is that somewhere if we can recollect all those principles and frequently we can use it in our teachings or in our research, then it will be very helpful for all of us, and then it will be a kind of contribution to revisit our rich culture, heritage, and ancient text. And when I gone through it, I realized that some of the portion or majority of the portion which we consider as a modern text, this modern text, they have the basis in the ancient texts which were written long back in the Indian background. So as far as relevancy is concerned, all these texts are very relevant even in the present context. Say for example, why it has a relevancy. Now, if you go through any text which is considered to be ideal, in almost all texts you will find that some are the basic principles which are which has the applicability universal. So, for example, if fire may be known with different names at different places, but the basic quality of the fire remains same. Or the basic ideology that your parents are the best guide and they can teach you all ethical and moral values. The same principle in different contexts may prevail in different, but the basic principles of ethics remain same. So the fundamentals of all the principles, rules, and regulations on which the modern text relies, you will find the basic of all in the ancient text. That's why the Mimamsa rules or the Mimamsa principles, which were written around approximately around 600 BC by Maharishi Jaimini, they have a very classified and detailed rules and principles which can be applied in different fields, be it as the field where human life or humanity or human consciousness is related, be it as the concept of dharma, be it as a concept of nyaya, be it as a concept of social engineering or the social structure, economics, political science. For each and every dimension, there were some kind of sutras which were written there. And if you'll read and go by all those principles, then you will find that the Western world have translated all such basic fundamental ideas with the modern examples. And they have tried to occupy the field whereby they were claiming that the Indian texts are not much relevant. They were not willing to give the credits to the ancient texts, but they were trying to take all the advantages. Say, for example, many of us might have read the interpretation, which is a very basic aspect which is relevant for all dimensions. Because even if you are a professor or academician with the area of sociology or political science, some or the other way you might have read different jurisprudence or the case laws or interpretation given by the judiciary. So, in all kind of interpretation or the kind of meaning which has been given by the judiciary in reference to particular dimension is based on some basic ideas. And therefore, understanding the text is very important aspect of all the academicians, be it as a researcher or as an academician of any field, because somewhere you have to rely on literature. How to rely on literature, how to understand the literature, and how to read in the exact frame with which it was adopted or enacted. That's why the principle of interpretations or the rules relating to the interpretations becomes very important for every individual. Because if you go by Justice B.S. Chauhan's few articles, he always says that the uh, difference of opinion is based on different interpretation to the text. If 10 people are there and the same text is been circulated to all 10 people, their approach in terms of understanding and interpreting the text would be different. So, in 10 different meanings of the same text, what would be the most appropriate interpretation or the correct interpretation of that text? How to understand that? That perhaps is applicable for all of us. When it comes to the research perspective, see, the doctrinal research, where most of the research is relied on secondary text, right? So how and secondary text where we have to understand that what exactly the meaning of this text, whether this text is relevant for us, whether that literature is relevant for our research, how much it is relevant, whether we are interpreting and perceiving it in the same context or not, and whether the same can be interpreted in different manners. For example, if a judgment has been delivered by Supreme Court in 1917, or for that matter, the judgments include sometimes the minority and majority opinion. We have seen multiple of cases where majority and minority opinions are conferred by the judiciary. And in due course of time, the minority opinions after some years becomes majority opinion. Due to change of perception, due to changes in the society, due to changes in terms of interpretation of the same text, or by multiple reasons. Because all this text, when it comes to interpretation, is not static, it's a dynamic. Since we say that the society is dynamic, is not static, then the law and the principles which are applicable or related to every dimension and aspect of the society or individual must also be dynamic. So then how the context was found relevant in that particular moment, which has changed the whole concept and converted the minority opinion into the majority opinion. That also is based on how you have perceived that text, or in what reference and in what manner that text was referred by the person who was arguing it. Which means there are basic principles of understanding of any literature, not only the legal literature, any kind of literature. So if you go back to the ancient text, which covers almost all dimensions of human life, be it social life, political life, family life, or all kind of principles. There were some kind of sutras, principles belonging to each and every dimensions. And all those principles are still very pertinent and relevant in the present context. So my basic purpose of today's discussion is that if somehow, because all these sutras and Vedas and ancient text, whatever I will discuss today is not even 0.1%. It will be only one of the view relating to some of the text. But if this 0.1% of text can change my perception overnight, if you go by all those, because perhaps sometimes the researcher fails to acknowledge the correct literature to connect, and then sometimes it fails that the idea which was already propounded, explored, and examined at multiple occasions, if the researcher is not aware, then the whole purpose of research fails. So therefore, when I revisited these basic documents and some of the principles, I totally have changed my view that the modern text or the modern ideologies are not very new. Or sometimes it is not only because of the changes and dynamism of the society. Majority of these texts and principles have a basic ideology or basic principles. And if you will go to the root of all this modern text, you will find the connection between the ancient Indian text, which has elaborated. So, for example, majority of Mimamsa rules, the interpretations, we have those who are the faculty of law or the student of law. We all know that the interpretation of statutes is a very important area which we all read, and until unless we understand, we say that if you have to understand the law, then you should understand the appropriate interpretation into appropriate manner. So there are multiple kind of books and principles which are lying there. The recent debate which is going on, that whether we should enact the principle of interpretation as an uncodified law, so that the uniformity can be intact, or the same text should be interpreted in the same manner and it should be perceived in the same manner by majority of people. That's the recent decision. That's the second point. But the alternate argument to this thought is that when it comes to the research, because the legal jurisprudence is also developed through various research. So in research, there are multiple sources, and the secondary source or the external aid to interpretation includes everything, which includes the Mimamsa principles and all sorts of principles, which can be taken as an add to know that what exactly the meaning of the words or sentences. So that's a single thing. So in this background, I have some of the PPTs which I would like to share, because many of the things were very new for me, and each of these specific terms has a specific meaning. So in generality, if I'll say, it will be combined with a concept that we had a very scientific, I'll say it scientific system and literature to justify each and every dimension, right? And all those terms I have covered only with reference to some of the because I was told that majority of the people from the legal background and the researchers. So how to relate with reference to the text in reference to research or in terms of any kind of literature, how it should be perceived and for what kind of specific approaches are there to understand this. So let me share my PPT. Are you able to see this? Is it visible?
Yes, sir. Yes.
So all this background which I discussed can be considered as a native jurisprudence, which I am very firm and sure that the ancient text and Indian jurisprudence was equivalent in terms of richness or in terms of quality. The modern text or jurisprudence which we consider is only the interpretation of all those basic norms. So sometimes it can be also understand as the propaganda against the ancient and medieval text. This is what my personal opinion, that the kind of text which we have with reference to any dimension, which can be considered as a legal jurisprudence also. So all those texts are because of some propaganda, because this British era uh, from of 200-300 years has changed the dimension and approach towards India and Indian text. And this is a human nature that we only believes in the kind of literature and text which is produced by someone who is I mean, either propagated or either presented in a manner that they have only the authority and the others are not having any kind of authorities. Say, for example, in international arena also, some of the texts relating to the international law, which also has some of the basic, if you will go and search on internet, the principles of Mimamsa relating to the international law, you will find the thousands of pages of Indian text, ancient and medieval text, which also relates to the principles relating to the international law and trade. So, for all those principles, because the venues of interaction of such international trade has shifted from India to at global platforms, therefore they have much convenience in terms of recent jurisprudence in interpreting multiple disputes. That is only their richness. But the principle on which they also rely, somehow they have the basis in the ancient and medieval text. That's what I have realized it. Now, so we have traditional principles of interpretation. Now, these traditional ancient medieval texts has a relevance with reference to research and teaching. These principles are known as Mimamsa principles. Now, it can be divided into Purva Mimamsa and Uttar Mimamsa. That is only with reference to the period. So, this Parashit Jaimini's period around 600 BC, that period where he wrote some of the text that is called the Mimamsa principle or the Mimamsa Sutras. This, if you want to read, there are some of the text which is available online through Tagore Law Lectures. It's a multiple series in which very briefly they have tried to I mean compile it to for make it I mean readily available for the readers to understand the basic concept. So this is one of the contribution of the Tagore Law Lecture series, where these Mimamsa principles they have divided into various parts, and they have provided in a readable format to understand the basic ideas. Because these texts includes thousands of pages relating and pertaining to each and every dimension. That's what I am repeating and again, that these Mimamsa principles are relating to each and every dimensions of human life, be it as a social, political, legal, and all. So we had a very legal system. So even at that point of time, what should be dharma? What the human behavior should be? What are the duties? So all those texts were based on some moral principles, and all those moral principles are up to an extent still depending on the circumstances which is applicable in different areas. Majority of these principles are still relevant. So they have divided into 12 chapters, and these chapters are considered to be the oldest opinions that have been provided there. That includes some of these principles have further interpreted by Madhvacharyas, Parsathi, Mishra, Manda Mishra. These are all the texts which are still available on net. So you can go through it. It's not that I have on exclusive, uh, I mean, the basis of these texts. These are all the texts which are available online, so you can explore it. The only thing is that somewhere we have lost it, or because in day-to-day life, or the kind of text or literature which we read has no reference of all these rich texts. That's why somewhere we are losing it. Many of the authors, sometimes Justice B.S. Chauhan, his majority of work, he has written 2 or 3 books, specifically with reference to the Indian judicial system and its relevance with the ancient text. That how this rich text was lost because of ignorance. And as I said, that there may be propaganda, and ideologically, because majority of that work of the modern or the recent time is based on these ancient texts, to claim it as their own, they have intentionally avoided all those references. So even if you will find that Maxwell's interpretation of law, majority of the principles are based on these Mimamsa rules, but you will find that there is no reference of these. Hardly at some places you will find that the Maxwell has interpreted or given the references of all these Mimamsa principles in the text. So how this very rich text of Indian culture or ancient Indian text has been ignored for a long period of time, and not by the Western world, but also by the Indian authors and researchers. So if be it as a researcher or be it as a teacher, if somehow we can correlate with all these texts, it would be a great achievement. And if we are conceding that the modern text or the Western text is very relevant and very elaborative, even we can make a reference and comparison that the same text is somewhere written in the ancient text of Indian culture also. So that must be included as a part of our research and our preparations for the classes, so that we can again bring it back into the light of, because otherwise also we have this moral duty, because this text otherwise is also very pertinent and relevant at all the ages. So even if you want to make any reference in the present text or present word, it will have 100% relevance, except in some cases where the society has drastically changed the norms. Say, for example, with reference to the live-in relationship or the other parameters in which some of the sutras would not be applicable. But that can also be applicable, because in reference to the changing society or changing parameters, for that also they have provided the scope that how to interpret with reference to different dimensions. So some basic assumptions with which these Mimamsa rules are required to be understood, that based on conviction that there is nothing redundant in Vedas. These Vedas are very written scriptures, and each and every sentence and word conveys a very specific message and does not in foolproof way. There may be multiple kind of why this is not in foolproof way, because multiple interpretations can be given. If you will not stick to the norms with which these interpretation has been provided, then it may lead to some other conclusion. And it has a own approach of Shabdabodh, which is understanding of words. That's what we say, that how to understand the words and its meaning. This is a very basic principle of interpretation. So different from those of both Nyaya and Vyakaran. So justice has a different meaning, Vyakaran, which means the manner in which the words are used in the sentence, they also have some specific meanings. And also the principle of apurv and adrast. Apurv means which was not happened earlier. Apurv, which पूर्व में जो नहीं घटा and adrast जो इसको पूर्व में देखा नहीं गया. So in case if something which happens in the society which is happening for the first time, how to take up that, how to decide all those aspects. This is very relevant because in present day context, all fields are having new and multiple challenges, which were not seen earlier, which were not experienced earlier. How to tackle all those things? For that also there are certain principles which are laid down. Then it can be divided. If since I was relating it, the Vedas, I'm telling you again that I am covering or dealing with only some aspects of ancient text in terms of Mimamsa rules. Even if you take the Mimamsa rules, it can be taught for the full 1 year with around 3 or 4 lectures every day. And even then, we will not be able to complete it. So that is only to explain that these are the texts which are, elaborative at multiple levels. So we are only covering touching one of the aspects with reference to the law or the research or to interpretation. So when it comes to the Veds, we know that the Veds are written and there are different kind of types of Vedas like Vidhi, Nished, Mantra, Namadhya, and Arthved. So for all these, there are texts. Say for example, in modern text, we say that we have different kind of law. We have a family law, we have international law, we have civil law, we have criminal law. We have the laws relating to justifying the rights of the individuals, the human rights. So classification of law is not the concept of modern society. Classification of law as per requirement of the society is the fundamental ideal and fundamental idea of the society which is written there in the ancient text. So even the Vidhi, if we'll divide the Vedas in 5 different categories, the first category is law. Law means Vidhi, which means Vedic sentences commanding or ordering specific action not previously known or validated by any other tool. So in case if there is any new tool, if there is any problem which was not faced earlier, then what you will do? Then the government will enact a law. So if in present scenario, if we were not having any specific law, say for example, right to privacy, we have to deal and we do not have any law. So the data protection bill is pending in it. Why so? Because earlier these kind of problems were not there. So now we are preparing a law so to deal with this new challenge that how to maintain the privacy and to keep it intact. So law means, so this concept which is applicable today, that for anything which was not experienced earlier, and if you have to deal that concept uniformly, then we need principles or set of rules. That is called vidhi, that is law. So that is explained at that point of time around 600 BC. And the same is intact and applicable in the product context also. And not only this, now you can classify also, and this classification was earlier present there also. Utpatti vidhi, viniyog vidhi, adhikar vidhi, niyama vidhi, parishankhya vidhi. These are all specific classifications. And if you can read it, that every law has a different kind of interpretation, and it includes different sets of rules to deal with. Then Nishad or Vedic sentence suggesting one to refrain from doing certain things. We also have many things. Say, for example, criminal laws, where we say that what kind of acts are prohibited, what you should not do, what is permitted, what is not permitted. From the Nishad was also there are, you can call one of the classification of this law as a prohibitory law, which restricts the actions or activities or act of the individuals to perform certain things. That is also mantras versus relying intending messages as well as actions required during rituals. If some procedural laws are there, that in what manner it is required to be performed, then the mantras are also there. Namedhi is the name applied to any rituals and product received from a ritual. Say, for example, in case if you have received something by law, then how to deal with that? Even some kind of examples, say, for example, in quasi contract, where you have given something to someone, and as in the product has increased by its multiplication, then how to deal with that? And similarly, the other way though also be sent as amplifying the message of Riddhi or Nished by praising them or cursing respectively. So different kind of interpretations were also there. I will not deal with the examples because if I start giving relating examples, then I will not even cross 2 or 3 slides. So I'll give only the example that what these Mimamsa principles, what kind of statements are there, which part is this relating to, and how it can be considered and perceived. So there are multiple elementary principles of Mimamsa rules or sutras are depending on these texts, like Sarthakya, Laghav, Arthikatva, Gan Pradhan, Samanjas, and Vikalp. And I will give you at the end some examples also. These are the basic principles or elementary principles, and the Supreme Court of India have relied on multiple times on these principles of Mimamsa rules. Like Samanjas, we all know that the harmonious construction is very prevalent and appropriate approach which has been adopted by the courts. Because this is very common that there are some kind of conflicts or the confrontation all the time. So how to harmonize it, how to balance it, and that is called Samanjas. So this Samanjas principle of the Mimamsa is not only applicable in terms of conflicting laws. Conflict is conflict, be it as a social conflict, political conflict, legal conflict, or conflict in your family. So how to deal with this conflict through Samanjas or through midway, whereby giving the importance to both the laws or by having a harmonious construction where the impact can be created and given to both the different dimensions. So these Samanjasya principle, Vikalp principle, in case if there are 2, 3 alternatives, then which alternative should be the best, or which alternative there must be some kind of alternative. So these Mimamsa principles, where these Sarthakya is every word and sentence must have some meaning and purpose. That's what we say is literal rules. That first you should rely on the text, and every text must have some meaning and purpose. And that meaning and purpose should be considered first. That's what the researcher also do. For the researchers, how this principle is relevant, that whatever literature you are reading, that literature must be understood with the purpose that what exactly the meaning and purpose to write this text. And it relates to which context. Because every text, if it is written, might not have relevancy all the time, except the kind of text which we are referring as an ancient text. So if you are writing an article today, that is also a kind of text. So you will write the article with reference to present context, where all the historical part or whatever has happened in that area previously, you will explain everything. But that is not sure that your article would be relevant after 2 years, because perhaps that scenario might change. Similarly, when you are conducting your research as a PhD scholar, your research topic, you are doing all empirical research, doctrinal research, and trying to give everything as a finding towards that problem to resolve it. But there is always a scope of research gap, so that you provide the scope of further research in that area. So your text, your literature, or the literature which you are referring might have relevance for that particular time, might not be relevant for the next time. But if you are reading it, if you are collecting it, you should consider all these dimensions, that this literature was written in what context, with what meaning, and with what purpose. So that it will always, you will be able to give a correct interpretation and correct understanding of that. Laghava also, the construction which makes the meaning simpler and shorter is to be preferred. We always used to uh, read the principles of interpretation and construction. The very basic difference between interpretation and construction is that in interpretation you mainly rely on the text which is available, and in general sense you are giving the meaning. But when it comes to the construction, where the meaning is not very clear, But to achieve the objective, you try to give a meaning through construction, where you create something or give a specific meaning which is required to be perceived in due course of time in all such cases. Similarly, adjective to word or sentence occurring at one and same place, a double meaning should not be attached. So if the same word is utilized at multiple places in the same text, then same meaning is to be given to them. Then gun pradhan, if a word or sentence purporting to express a subordinate idea clash with the principal idea, the former must be adjusted to the letter and must be disregarded. Gun pradhan means what exactly the quality, what is the nature. There are multiple kind of approaches or interpretation where we say that there is a genome created, where one is the specific word, one is the general word. So how whether the general word should be interpreted in reference to the specific word, or whether the specific word should be interpreted in reference to the general words. How to perceive it? If you have two different contexts and two different contents, you need to relate the content and to give preference to which one. That is relating to the guna pradhan, where the quality and the kind of specification comes into existence, and then you give the preference to it. And it happens with all the teachers and researchers also. You have multiple kind of semtext, and then you need to decide that if there is a contradiction, or if you have two different principle or ideas, which idea would be more relevant for you. If you have to decide it, then you must decide as per the quality of it. Samanjas, I told you, Vikalp is the alternate options. Then the golden or the general principle of rules when it comes to the Mimamsa, there are four different dimensions. One is Shruti, Linga, Vakya, and Prakaran. These are all the very popular terms. And these popular terms, when it comes to the Mimamsa principle, they have very unique meaning. So when it comes to Shruti, when a verb and a case governed by it have a self-evident meaning of this form, a complete and independent sentence, no attempt should be made to extend or twist the meaning. This is what the literal rule of interpretation. That when the meaning is very clear, you should not give any kind of other meaning. When the words or sentences are self-explanatory, then it should be perceived in the same manner. This is what the literal rule of interpretation is. Be it as in Maxwell's interpretation or in modern interpretation, by all means. So whatever is written here now in the different formats of the Western world, the same meaning, how or from where they are deducing all those principles mean. The literal rule of modern text for interpretation is this Shruti. Similarly, Linga, when the meaning of the word or express is not clear on the face of it, and its latent force or suggestive power has to be brought out by the suggestive power of some other words or expression. This is what the construction. That when the literal rule or the words are ambiguous, where the meaning is not clear, then you can take the help of others to draw a right conclusion. Then Vakyas, where what is apparently a complete sentence has, in order to make out a satisfactory sentence, to be read as a part sentence, connecting it with some other clause. That's what we say in modern context, that the institute must be read as a whole. Which means if the meaning is not clear of the sentence, then you need to relate to the same text, the paragraph or the complete text. Sometimes that's why every act they have the object of its enactment. So in case if any provision is ambiguous and in reference to its enactment you have some doubt, you go and refer to the objective clause where it is referred that with what purpose and what is the objective of this enactment. So somewhere you need to collect it and recollect it. Then prakarana, when a sentence or clause by itself does not indicate its purpose, but its purpose becomes clear when read with some other text belonging to any other topic discussed. That means the external aid. It's not only sometimes the text is clear. So then if you take the external aid as an help to find out the purpose remains same, that how to draw the appropriate meaning of the text. And these all are the additional adds to it. So then general principles of applications of text. Now with reference to the text, there are multiple different terms like Adhikaran Vidhis showing to whom Vidhi texts are applicable. The Krama means order in which the texts are to be applied is determined. Say, for example, if we have to give importance to a judgment, there is an order that if there is a lower court's decision, then lower court decision, if it is overruled by the High Court, and if the High Court decision is overruled by the Supreme Court, the most appropriate text will be decision of the Supreme Court. There is a sequence. So similarly, there may be sequence in different format with different text. If the text is released by some authority which is lower than the other authorities, obviously you should prefer one which is acceptable in some appropriate diameter. Then references rules regarding one matter are made to bear and another matter depends on the different rules. Then adoption in course of effect of Atidesh, necessary modifications are to be made in secure proper adoption. These are with reference to the text, they have given some kind of example and that how to read it and how to perceive it. Similarly, there are multiple kind of maxims. These are very, very important. That the modern maxims which we are reading, multiple kind of readings are there, multiple kinds of maxims are there. Or for that matter, if I take this liberty to say that all the modern maxims which you are finding either in any specific languages, you will find it has some alternate or same kind of meaning or text in the ancient text of Mimamsa rules. Be it as redundo singular assembly or be it as a judgum generis or all these modern text maxims which are referred in the modern text, be it as a Maxwell's principle of interpretation, you name any maxim, you will find the text of similar nature in the ancient text in Mimamsa rules. So, which means this one thing is very, very, very established that the ancient text was very genuine in nature, considering all dimensions. We have the modern or the Western world have only changed its perception and interpreted as per the requirement of the society. They have only added the examples with changing the names of the maxims and its applicability in case of any conflict. The basis of all these modern texts or literature is the ancient text. So that's why there are thousands of maxims, not even one, two, or three. And all these maxims are classified when it comes to the text or literature. So I have classified in categories. See, for example, there are some of the maxims classification, like class 1, group A, the sense attached by the current users, it's to prevail. Some, the wooden sword maxims, Aruni maxims, Sastric use of words. So they have classified in different groups, which means relating to the sentences, relating to the text, relating to the words, relating to the collection of words, relating to the strict construction, relating to the golden rule of interpretation. Whatever classification of interpretation you are finding in the modern world, each and every dimension. That's why I'm saying that the exhaustive and elaborative work, which has some of the parts have taken from all those sources and explained in reference to the modern context. That may be, as a conclusion can be drawn, that all those maxims, there are multiple kind of maxims which are not even you will find in the present context. Be it as because of that kind of system is not prevalent now in society, or the maxims have no relevance in the present society. Which means if the thousands of maxims were there, if 200 maxims were relating to that particular time, the 800 maxims are now available to interpret in the modern context. What the Western world is doing these days. And they are presenting, and we are considering that yes, their maxims and their interpretation is very relevant. So it's not. So we are not taking something from them. They have taken it, interpreted it, then classified into different categories. They have given different names and reproduced it. It's a similar kind of example that you are purchasing your international brands, which is prepared in India, and they have only made their stamps on it and send it back, and we are purchasing it at a very higher price. All those materials which is stitched, the very fabric is collected in India, the styles and the traditional way of preparing it is Indian. Uh, the texture is also Indian. Design is also Indian in some point of time. What they have given, they have only given their name and reproduced there, which we consider that's the very, very best quality. So the same analogy applies in reference to the ancient text, that they have taken the basic ideas of all those texts, reproduced it, renamed it, and provided worldwide with their own name without referring even the original text. That is what has happened when it comes to the principles of Mimamsa, which has a very pertinent and relevance with that. So, if we think of relating all those principles in the modern context, then it would be very easy and convenient for all of us. I'll give you some of the examples. Say, for example, in this Tribhuvan, Tribhuvannath was at DIOS 1992. There was this case where the interpretation was with reference to deciding the seniority, that how to fix the seniority. And this is there are multiple kind of cases where the Mimamsa rules have been adopted by the Supreme Court, and at multiple occasions, they have said that the modern text is very limited in terms of interpretation, whereas these Mimamsa principles have a greater relevance at that point of time. So, in this, when it came to determining the senior most teacher in an intermediate college, that was a dispute to determine the seniority of a teacher. That was a question. And the writ was filed in Allahabad High Court claiming that the appointed ad hoc principal on the retirement of the previous principal, but the management had superadded him. In the course of hearing, there were two different opinions given by two different benches. Means single bench has given different opinion, divisional bench has given a different opinion in terms of counting the seniority. It says that when there is a vacancy of the principal, the senior most teacher would be considered as to be appointed as a principal. Now, how to consider? Now, in this case, the seniority was avoided, and the not the senior most, but the second in row, that person, he was superseded and appointed as a principal. So there were two different aspects, that whether the senior most principal, the faculty member should be considered the sole criteria, or in certain cases exceptions can be created. Now, by taking the help of Samanjasya principle, the court has very categorically explained the Samanjasya principles of Mimamsa rule in this case, and tried to harmonize both the approaches. They say that the normal rule is that the senior most faculty should be appointed as a principal in case of vacancy, but in case if there is any adverse remark, be it as any case is filed against him, or if there are serious allegations on the senior most person, then in that condition, the alternate may be considered, and the next in row, whosoever is the senior most person, can be given the charge. And by that way, they have tried to harmonize both the approach. That not only the senior most person should be appointed as a principal is a general rule, but in case if exception has been created, that is only possible when there are some serious allegations against the senior most persons. So this Samanjasya principle was adopted by the court in this case. Similarly, this another case of this Sardar Muhammad Ansar Khan versus state of UP, 1993. In this case also, the promotion of head clerk and the promotion of teacher, applicability of the promotion rule was in question. So when it comes to the promotion of the teachers, they adopted a rule that whosoever is aged, means the age was considered as the criteria. So date of birth was the criteria on which the seniority would be determined when it comes to the promotion of the teaching staff. And when it comes to the appointment or the promotion of the clerical staff, that norm was changed, right? So, with reference to adopting these two different approaches for the same term, which means in case if the promotion of the teacher is there, you have said that the date of birth would be criteria. But the same criteria was not considered when it comes to promotion of the clerical staff. So there was a problem, and this was challenged where the court adopted the Atidesh principle of Mimamsa. Now, how they have explained the Atidesh principle of Mimamsa, they says it was held that the same principle which applies to teacher should also be applied to the clerk, and hence the senior in age would be senior. There is no right, which means if there are these conditions remain same, then you cannot adopt two different parameters. If the the only criteria when it comes to the promotion, if you have adopted the date of birth as a criteria, then take this criteria for all the promotions, not by classifying, which means you are making a classification that otherwise also would have been argued avoiding this equality before law. So, so in this case, the court categorically explained the Atidesh principle of the Mimamsa rules and then it says that the matter of performance is given in the tale of Brahmas. These are the known and Prakriti Yagyas. However, there are other ways to interpret, but this Atidesh principle, which has a very clear norms relevant for the present text or the present situation, which was there in this case, and therefore the court says that there is no need to go to any text to consider for its interpretation, and they have given the interpretation to this. Now, similarly, if there is another case of Vinay Khare versus the state of UP. In this case also, let me just explain. The controversy was with reference to competitive examination. Two candidates got equal marks. Whether the candidate who got more marks in the oral interview should be placed higher in the selected list, or the candidate who got more marks in the written test should be given preference. So it was held in this case that the candidate who got more marks in the written test should be placed higher because to interpret general suitability on the basis of marks in the written test is a short and simple interpretation, and it provides a clear objective test, whereas the criteria in oral interview involves consideration of candidates' personality, dress, physics, and many other grounds, which is complicated and in which there are more chances of favoritism and arbitrariness. And this was also based on the same Samajasya principles. And the court has also explained the Samajasya principles in that. Since and in next case, it's Gujarat Urja Vikas Nigam Limited versus SR Power Limited. In this case, also the Supreme Court has relied on Gun Pradhan exam, which, with reference to the applicability of or interpretation of two different provisions, that is Section 173 and 174 of the Electricity Act, and while there was ambiguity, and to clear that ambiguity, they say Gun Pradhan exam means where the interpretation should be relied on the basis of its character and its nature, what exactly the gun is. So section 173 and 174 of the Electricity Act, let me just read the important part of this judgment because this judgment is very long judgment, but to understand only relevant part I am reading it, which says that the Gujarat High Court appointed an arbitrator under section 11(5) and 6 of the Arbitration and Conciliation Act of 1996. The main question before the court was whether the application under section 11 of the Arbitration and Conciliation Act is maintainable in view of the statutory specific provision contained in Electricity Act, that is section 174 and section 175. Now, what this section 174 and 175 were, that what section 174 says, that the said act will prevail over other laws, and section 175 says that the said act is in addition and not in derogation of any other law, which includes section 11 of the arbitration. So which means that there were two different opinions within the same act. One says that the arbitration and conciliation would have act will prevail over the other laws, right? Which means the Electricity Act will prevail over the Arbitration and Conciliation Act. Whereas section 175 says that the said act is in addition and not in derogation of any other law, which would include arbitration and conciliation. So there was a which interpretation or which meaning should be adopted, and therefore the court relied on the Gun Pradhan axiom or the rule of Mimamsa, which says that if a word or sentence purporting to express a subordinate idea clashes with the principal idea, the former must be adjusted to the latter and must be disregarded altogether. And considering this, they say when primary and belonging to two different interpretation, then they relied that the section 174 of the Electricity Act is pradhan, which means main provision, whereas section 175 is gun, it is character. And that section 175 of 2000 Act cannot be read in isolation and is to be read with section 174. And reading together, the meaning is given to section 11 of the Arbitration Act, which says that the commission and the central commission nominated by can resolve such dispute and they have the authority. So instead of, if they would have relied on only one section, like section 174, then the meaning would have been different. So the court said that if there are the Gun Pradhan exams or the rule where on the basis of its objective and specification which has been given, by considering those, if a meaning can be drawn, then that meaning should be given. And these are only few examples. There are thousands of cases in which these Mimamsa principles are adopted by the courts. Now, these are only examples. The examples for with only with this object, that the Mimamsa rules, which were propounded long back, it's around 600 BC, has still relevance to resolve the present disputes. So why to take up? Now, the second dimension would be that if people at large, be it as the professor of law or student of law or of any stream, be it as from sociology, political science, or for that matter, any stream, if we go by the principles and the ideas which are reflected in these ancient texts, then majority of problems can be resolved rather than taking it up to the courts. So if during our research, if we consider some of the principles which are available in this ancient text in elaborative form with examples, it will be very helpful for all of us to understand those basic concepts. Sometimes we say that the international book on of any specific author is very complicated because we don't find any Indian text or examples in those. So if, because they have taken the references and they have interpreted in their own context. If we'll go by our own text, which is available there to understand and perceive all those basic ideas, we will relate it. We will have the examples also and we'll have better understanding. So my only this effort to relate with the ancient text and to somehow encourage all of us, including me, that wherever we are perceiving or wherever we are conducting any research or or analyzing some literature in any context, if these ancient texts would be referred, it will certainly give a better idea of understanding of those concepts. And we will be able to even analyze that how far these basic ideas have changed as per changing dimensions of the society. So this would be, this is what I was just trying to discuss within the stipulated time. If there is any question or where we can discuss something, then I will take leave because I had some other engagement at 1 o'clock. That's why I took the.
Okay, so this the session is now open. Thank you so much, sir. Thank you so much for your words and correlating this philosophy. So, if there are any questions, I would request to ask. I would request the participants. You can raise your hands, or you can directly ask to sir. Okay, so sir, for now, I don't think there are any questions.
So there are two meanings of this situation, which we all
Yeah, which we all know, which we all
I,
know.
I consider it favorable to me that it's clear to all.
Absolutely, sir. No, sir. Actually, I would honestly say this session was really helpful. And the other day we also had another session with one of the professors from Banaras Hindu University, Professor Ratate, who was also discussing in similar lines. So I think that has also converged. All these ideas have converged better into the minds of the participants here. And on that note, sir, I would thank you once again for accepting our invitation and enlightening the students here with your words of wisdom. So thank you so much. Thank you so much, sir, and have a good day. Thank you, sir.
Thank you once again. Thank you.
Okay, so the participants will join again at 2, and we look forward to the next session. Thank you, everyone.